Hello and welcome to our latest in the series for our Regen videos. I'm Adam Hayward, an Associate Director in the Real Estate team, and today we'll be talking about public procurement and how that affects Regen schemes. So as part of our work on Regen schemes, we often advise clients on a wide range of linked issues which arise at different stages of the process. Every scheme is different, so those issues vary from case to case. But one topic which comes up quite regularly is the interaction of regen schemes with the public procurement regime. This is a hot topic for schemes brought forward with a public sector partner or where there's significant public money invested into the scheme. And for most large schemes, there is usually some form of relevant interaction with the council, whether they're the landowner or maybe the JV partner or some other element. And it's important that the council and the developers get the procurement process right to avoid any challenges that there might be in the future. So today I'm joined by Laura Thornton, an Associate Director in our public procurement team, and she's going to talk about public procurement issues and how they may impact regen schemes. So, hi Laura. Um,
Hello.
First off, could you please explain why the procurement rules may apply to regen schemes?
Yeah, thanks, Adam. Morning, everybody. First of all, there's a number of scenarios, as Adam's just highlighted, where public procurement might interact with a regen scheme. I think the most common is where you have a public sector landowner looking to develop a site with a JV partner, and that JV agreement will ordinarily be a public contract subject to the procurement regulations. There's also scenarios where grant funding from a public body, perhaps Homes England, will also bring the agreement within the realm of the public procurement regulations, subject to the degree and scale of that funding. So you'd need to comply then with the procurement regulations when you're setting up that JV or partnership agreement, but also depending on what's procured at that stage and the scope of the procurement, you may also be procuring partners and services down the line when you get to the stage of needing development management agreements and estate services. So it can be relevant throughout the life of the regen scheme.
Okay, so right, we've got our JV established. So should we just run through why procurement still remains relevant to those schemes after that's been established?
Yeah, absolutely. So regen schemes, by their very nature, are long-term projects and often changes arise over time. So even when there's an agreement put in place at the outset, it may need to shift or be varied over the course of its the building and the planning process. So there might be changes which result from perhaps shifting economic circumstances or maybe adjustments following the planning process. There's very detailed and quite rigorous rules around when you can make variations to a public contract. And so developers should be very aware of the restrictions that exist within that regime.
Okay, and so what is the position now if you need to have a change to a public contract?
Yeah, so as I say, this is a really heavily regulated area. The first question you need to ask yourself is whether that modification is a substantial change. And what is substantial is set out in the regulations here. And it includes a number of factors, but broadly where the variations would result in a contract of a materially different character to the one that was procured, or importantly, where there's been a change of economic balance in favour of the supplier. So in those sorts of scenarios, you need to bring the change within what's called a safe harbour within the regulations. And there's two main safe harbours that are sort of frequently used here. Others do exist, but these are the most relevant ones. The first is that the modification was permitted in clear and unequivocal review clauses in the original contract. The bar for those clauses being clear is quite high. You need to really make sure that you've set out exactly the sort of change that might be made and the circumstances in which it would be brought forward. There's also a caveat that there needs to still be no change to the overall nature of the contract. That safe harbour, though, has no value cap, so it could be a doorway to quite substantial financial changes. So where there are potential changes during the life of the contract anticipated, that's the most relevant safe harbour, provided you can set out at the outset in sufficiently clear terms how those changes might come forward. The other safe harbour, which is sort of the antithesis of that, is where changes or the circumstances that led to the change weren't foreseeable by the diligent contracting authority, the public body. This safe harbour would enable an increase in value up to 50%, but again, it's subject to that caveat that there mustn't be a change to the overall nature of the contract. There's care needed around this about the knowledge that a diligent contracting authority had or would have been expected to have at the outset. So for example, a change of economic conditions leading to a refocus of a development from commercial to residential might be something which couldn't have been anticipated earlier, and it may have arisen only after the agreement was entered into. But equally, it might have been something in contemplation for some time, even just on a sort of risk that may arise basis. So in order to rely on this safe harbour, you need a really clear audit trail setting out the thinking at all of the relevant times so that you can point back to the reasonableness of the fact that this particular change hadn't been anticipated earlier.
What I'm taking from that is that you need to think about the deal at the outset, but then you need to think about what could happen in the future during the process, because most of these regen schemes are years and years that keep going down the line. So just thinking about what could change, build that into those initial discussions, and then you've got that second limb of what
Yeah,
just couldn't be foreseeable.
exactly.
Really interesting. You also mentioned that the law in this area is due to change. So what's coming down the line?
Yeah, sure. So the procurement bill is before Parliament at the moment, and it makes quite a few changes to this area. So although the existing safe harbours will continue with some small adjustments, there's going to be some new safe harbours. And there's one which is, I think, of particular interest to developers, which is the materialisation of a known risk. So this is quite a detailed set of rules you have to jump through, hoops you have to get through to bring yourself within this safe harbour. So you need to have identified the risk in your procurement documentation. So you need to know about it as a risk from the outset. And then one of those risks you've identified has arisen, but not as a result of either an act or omission of the authority. As a result of that, the contract can no longer be performed to the satisfaction of the authority. And then the modification that's made in response to the materialisation of that risk can go no further than is needed to remedy the risk which has materialised. So it's constrained in the extent of what you can change. It also needs to be the case that further competition is not in the public interest and the modification doesn't increase the overall value of the contract by more than 50%. So there are quite a lot of hoops to jump through, but we think risks like market changes, delay, potentially unexpected ground conditions might be set out as risks at the outset to enable reliance on that safe harbour down the line. So it might be that we see publications of quite long lists of known risks to, again, build in the possibility of using that safe harbour down the line if things do change.
Interesting. And when are those changes expected to take place?
So it's obviously a bit dependent on parliamentary time. The bill's in the House of Commons now, and it's currently expected to be in force early 2024. We're going to be keeping a close eye on this topic at Osborne Clarke, and so please do come back, look at our website. There's going to be more updates published as the bill progresses and the changes are more crystallised.
Yeah, perfect. Thank you very much for that, Laura. And it sounds as if it's probably a good idea for clients that are starting out on their regen schemes to speak to you and the team, because you're obviously
Yeah.
involved in so many. So just getting those thought processes in place early on, you might have a number of ideas that might apply to their regen schemes. So good to get you involved
Yeah, we're always happy to have a chat.
as early as possible. So thank you very much, Laura, and we'll take it away from there.